What it promises is nothing less than a fair shake for every American.
The 14th Amendment of the United States claims to provide that no state shall deny to any person within its jurisdiction the protection of equal laws. This can be explained as the Equal Protection Clause. This clause was established in 1868 under the United States Constitution, as it can be associated to the Civil War and the Reconstruction. As the clause was active, it meant that the state must treat every individual in the same manner as others under similar circumstances and conditions. This keeps the state from classifying individuals convicted of a crime to be categorized and punished solely based off irrelevant government action.
Throughout history, there have been many examples that violate this clause. The Plessy v. Ferguson case, in which the U.S. Supreme Court on May 18, 1896, by a 7-1 majority, helped the controversial separate but equal doctrine for assessing the racial segregation laws. This case was one of the first major investigations into the meaning of the 14th Amendment, as it provided the laws designed to achieve racial segregation by means of separate and supposedly equal public facilities and services for African Americans and whites. However, it was overturned in 1954 by the Supreme Court in Brown versus the Board of Education, as states could segregate public schools solely based on race. But Brown voided that decision and stated that separate is evidently unequal.
If you look at Brown versus Board of Education, that's what led to integration of schools in the South and nationwide. We're learning from our mistakes. And if you look at the Section 1 of the 14th Amendment, that's where this comes in. But
And so when it comes to equal protection of the laws, for example, it matters not a whit that some of the drafters of the 14th Amendment were racists, because they were, or sexist, because they were. The law they drafted promises equal protection of the laws to all persons.
The Equal Protection Law, we believe, is one of the most important statements in the United States Constitution and was created within the best intentions of the framers. Within the people, however, the Equal Protection Clause is viewed differently, as there are people who have different views on the 14th Amendment in regard to who it really protects within the groups and cases.
Equal protection doesn't mean a lot to me. As an African American and as a U.S. citizen, I don't think equal protection is something that we get benefits from it.
There are many factors that play into equally protecting the citizens of the United States. However, since the clause was established, our society has grown and has changed in many ways that would be unthinkable for the framers. These include the acceptance regarding various of the ethnicity, sexualities, and customs. However, stereotypes still inhabit our minds and do play a major role in our society.
Regarding race and the Equal Protection Clause, there has been a lot of discrimination in the system, but there's a lot of leeway for the Caucasian society. The poor and the ethnic minorities, however, have not been afforded the equal protection that the middle and upper class, mainly white communities, enjoy. This chart compares different race percentages in jail and who was mostly incarcerated in 2010, with blacks being among the highest, Hispanics being in the middle, and whites being among the lowest of the bunch.
Existence from an African standpoint. Because, just like I said, and I repeat that, we are a minority group in this country, but when you go into the jail, county jail, you go to a state penitentiary, you will find out that there is a majority of black people inside, but we are, as a minority, it should be, if there is equal protection, we should have same rate.
As simple as it is to understand, The meaning of the Equal Protection Clause, it can be broken down into many factors and arising questions. One of the many questions these topics deal with is the scrutiny and the extent in which its level apply regarding to the Equal Protection Clause. There's 3 levels to scrutiny: strict scrutiny, intermediate scrutiny, and rational basis scrutiny. Strict scrutiny in the states interest in the least restrictive way, meaning that the law has to be secure for national and fighting discrimination. These include the race, religion, etc. Intermediate scrutiny must have an important state interest and must be substantially related to achieving the interest. Rational basis has a legitimate interest in that the law rationally undertakes. This can fall under mentally challenged people, LGBT, children of illegal aliens, etc.
The reason there's always multi-levels of scrutiny is so that you're not basing it on one thing. Does that make sense to you?
Yeah, that makes sense.
So if you can scrutinize something 3 different ways, then that way you get a better outcome.
Overall, the equal protection was created by our founding fathers to protect individual rights that were being discriminated in all types of ways: genders, race, sexuality. Our founding fathers didn't know that creating the equal protection can cause a great confliction between the equal protection favoring one race over the other. The question today that people ask regards the court's incarceration of the right people under the correct clause and if it is equal, as well as command in our communities that involve basic human rights. However, as we have understood, the equal protecting clause is misunderstood and may have conflicting arguments against it.